Good morning, everyone. Echo. Good morning, everyone. Welcome to our panel on Supreme Court, our Supreme Court Roundup. It's an annual favorite. Every year we do this. So I'd really like to welcome you and thank you for coming. My name is Dr. Christine Pappas, and I'm the chair of political science at East Central University. And we have with us on the panel today a great mix of legal professionals. Jacintha Webster, who is an attorney and now also assistant professor of legal studies at East Central University with McGirt versus Oklahoma, is going to be the case she talks about. We have Alex Courtney, who is a current law student, 2L at Oklahoma City University School of Law. He'll be speaking about the case Bostock versus Clayton County. And we also have Professor Andrew Spiropoulos, who is the Robert S. Kerr Professor of Constitutional Law and Director of the Center for the Study of State Constitutional Law and Government at OCU. And he'll be talking about the Religion Clause cases. And we also will have some time to talk about Supreme Court politics, including the current or the newly confirmed new justice, as well as perhaps the Affordable Care Act case that's going to be coming up pretty soon. So we're going to take these panelists in the order in which they appear in your program. We're going to start first with Jacintha Webster speaking with us about McGirt. Thank you.
Thank you, Dr. Pappas, and thank you for asking me to be on this panel. We previously already had a pretty in-depth conversation about McGirt in an earlier panel with some really, really brilliant people, so I don't want to repeat too much, but I know that some folks maybe weren't on there. But so basically, if you're not familiar, which I think everybody is, if you I don't know, watch the news or on the Facebook or the Twitter or whatever, that McGirt versus Oklahoma is a case regarding the Creek Nation Reservation. So in order to really understand McGirt, I'm going to take you through a really, really brief summary that normally takes about half of an Indian law class in law school of criminal jurisdiction in Indian country. So basically, as we know, tribes in the US were removed onto reservations into Oklahoma. And then what happened was those tribes, after they were removed, were still engaging in activities that the US government thought was crazy, like communal agriculture and communal land ownership and all of this stuff. So the government, in a further attempt to have tribes act more the way that they felt like people should be acting in relation to land ownership, decided to take those reservations and divide them up. So that was through the General Allotment Act, or also called the Dawes Act. So in the Dawes Act, they divided up the reservations in Oklahoma and other places and gave allotments to heads of households or individual Native people. And those allotments were 160 acres to 300 acres, kind of depending on the tribe. And those little pieces of land are actually still being passed down to Native people today. So we have these allotments in Oklahoma, and it was always sort of assumed by everybody that those allotments have been made automatically broke up the reservations and made them no longer exist. And in some instances, there were specific documents saying, and therefore this reservation is disestablished. I apologize. I'm in an office right now because my house doesn't have internet. The reservations were disestablished in some instances. Now, we have these allotments, right? The other thing you need to understand about McGirt is how we get criminal jurisdiction within Indian country. So within Indian country, criminal jurisdiction exists when you're either inside a reservation, right? So inside an existing reservation, or a dependent Indian community, which is mostly pueblos. So we don't really deal with that a whole lot here. And then also on a allotment or on land held in trust. So either on one of those individual little pieces of property that's held by a Native person, either in trust or restricted status, or on a piece of property that's held in trust for a tribe, like at a casino, at a travel plaza, at a tribal headquarters, something like that. If you commit a crime, if you're Native American and commit a crime in that area, or you are non-Native and commit a crime against a Native American person in that area, you're subject to a different type of jurisdiction than the state. If you're a if you're a non-Native person who commits a crime against a non-Native person, no matter where you are, the state has jurisdiction over you, okay? The question is when you have a Native person in the mix, right? When you have a Native person either committing the crime or having the crime committed against them. Going back to McGirt, right, we thought that the Creek Nation had been disestablished along with a lot of other tribes because allotment had happened, right? We broke up the reservations, we gave everybody these little parcels, which conveniently left a lot of leftover land for non-Native people to settle on. So we assumed that. The difference that happened is that nothing ever really officially said Creek Nation is disestablished. And apparently, or at least allegedly, there might be some other situations where nothing ever said these other tribes' reservations were disestablished. So what happened in McGirt and also in Murphy, which is a companion case, is a Native American person committed a crime within the boundaries of Creek Nation, but not on one of those little allotment pieces. So what happened was some really bright people at the Federal Public Defender's Office, namely Patty Gezzi, determined that, hey, I actually don't think that there's any document that says this reservation was disestablished. And they took that up, the 10th Circuit agreed, and then ultimately the Supreme Court and Justice Gorsuch wrote the opinion that said that indeed nothing ever officially disestablished the Creek Nation reservation. And so that means that for purposes of criminal jurisdiction, right, for purpose of criminal jurisdiction, a Native person who commits a crime against anybody is subject to either tribal jurisdiction or federal jurisdiction if it's a major crime, and a non-Native person who commits a crime against a Native person is subject to federal jurisdiction if it's within the boundaries of Creek Nation. And this case is significant not just because of the ramifications of there being a reservation in Northwest or Northeast Oklahoma, which we didn't think there was, but also Justice Gorsuch, who, as Professor Ross talked about on the previous McGirt panel, he's from the 10th Circuit and he has been very favorable towards tribal interests. He, being from the 10th Circuit, he is very understanding, has a really good grasp on federal Indian law. And he's also a textualist, right? He believes in looking directly at the text and not extrinsic evidence of potential thoughts, intents, outside circumstances, right? So him being someone who's well-versed in Indian law and him also being a textualist created kind of this perfect situation for him to write this opinion. And this opinion is really important because he looks specifically at the texts of the documents. And there's a test that's applied, it's from Solemn versus Bartlett, and it says that when a reservation is disestablished, it can only be disestablished by Congress. It can't be disestablished by the president. It can't be disestablished by the state, right? Because if states could disestablish reservations, every reservation would be disestablished because those are inconvenient to states, right? So the only entity that can disestablish reservations is Congress, and Congress has to do it affirmatively and explicitly. And Gorsuch says there's no magic words. It's not like this specific phrase has to be used, but it has to be done in a very specific, obvious manner. And there's just, they combed through every document that ever had to do anything with Creek Nation, and they found nothing that explicitly said, you know, and now the reservation is going to be disestablished. This is really interesting because if you look at the past history of Indian law, you know, in the last 50, 100 years or so, it's been a really results-driven body of law. There's a lot of thought put into opinions about Indian law saying, well, is this result going to be fair to non-Native people? Is this result going to have an unintended consequence that we don't like? Rather than looking just at the black letter of the law, there's a lot of, in the past, the Supreme Court has, when they talk about Indian country, they do a lot of results-driven findings. And certainly, I think that's what the state of Oklahoma was looking for in this case. There was a lot of doomsday predictions happening, and Justice Gorsuch rejects that. And he says, you know, you don't look for outside circumstances to find ambiguity. Ambiguity can only be found in the text. And there's no ambiguity because nothing says this reservation is disestablished. And that's really, you know, I think a lot of Indian law scholars are hoping that this is a turning point in Indian law, because it's actually treating Indian law the same as other bodies of law, which is to look at the actual text first and not be considering these extrinsic circumstances. He says specifically, Justice Gorsuch says, he talks about if we had found something different in this case, that would be the rule of the strong versus the rule of the law. And I love that, because that's completely contrary to how Indian law has been treated previously by the Supreme Court. Normally it's been treated as, well, is this a fair, does this make sense with how we want to treat Native people? Does this make sense with, you know, how outside communities will be affected? And he says, that's not my problem. Like, how this might affect other communities, like, y'all can figure it out, because the state of Oklahoma and the tribes have had historically, notwithstanding the recent gaming dispute, really good relationships with compacting. And he says, you know, extrinsic circumstances are really, he doesn't literally say they're not my problem, but he basically says, you know, that's not something that's appropriate to look at here because the text is clear. So that's why I think it's a really exciting case in Indian law, and just in general when looking at, you know, how the Supreme Court's going to be going forward with analyzing treaties and analyzing legislation.
Wonderful, thank you. We're going to turn now to Alex Courtney, who's going to talk about the case Bostock versus Clayton County.
Hi, everyone. Dr. Pappas mentioned earlier, but I'm an ECU alum, so I'm really excited to be able to talk about this. LGBTQ issues are also something I hold pretty near to me. It's why I went to law school. So I'm excited to talk about Bostock, which is how LGBTQ people got protections from Title VII's 1964 Civil Rights Act. So we had no protections for LGBTQ people before this summer. The Rights Act was passed in 1964. In the last couple years, we've had a few cases. It was the Second Circuit, the Sixth Circuit, and the 11th Circuit. In the Second Circuit, the Supreme Court, not the Supreme Court, I'm sorry, the Second Circuit held that you cannot discriminate against someone for being gay. The Sixth Circuit said you can't discriminate against someone for being transgender in your employment decisions. And the 11th Circuit said that you can. So the Supreme Court granted certiorari so that they could fix the circuit split. And again, this was another kind of surprising Gorsuch opinion. And he also relied on textualism to come out with an outcome you wouldn't really expect from textualism. And he said that sex is inextricably bound up with sexual orientation and gender identity. So donut
Is
holes.
anybody else froze up?
Alex, you were frozen there for a second.
Oh no, where did you lose me?
It's okay. Just go back like to your last sentence.
Okay, he said that sexual orientation and transgender status are necessarily bound up with sex, because you can't have either of those things without the other, because homosexuality is attraction based on sex. Gender identity and presentation is you may or may not present as the sex you were assigned at birth, and you might not identify with the sex you were assigned with at birth. He said there was no canon of donut holes, and that just means that this is a pretty generally and broad statute. So the fact that there's not a specific instance of some kind of discrimination doesn't mean it'll be necessarily excluded and not counted as a claim. And we can get sexual orientation and transgender status out of sex because we use the but-for test, which is a pretty broad test itself. And it means that those don't have to be the primary reason for firing someone to be a violation of Title VII, but it does have to be something that, if it didn't exist in the facts, would not lead to that person being discriminated against. One second. There was an argument that mostly this hinges on the textualism turn of how do we interpret the words as they were written then. So in 1964, the dissent would say that nobody could have possibly assumed that this would protect sexual orientation or transgender status. But the majority counters that and says within the first year, there were already claims for Title VII for LGBTQ people, specifically gay employees. And then within a decade, transgender people were making the same claims on that status. So to say it wasn't thought about is probably not likely. There's also a lot of, there was discussion at the time of 1964 Civil Rights Act saying this could possibly help people, LGBTQ people, from being fired for being gay. But that just also shows you they've talked about it. Justice Kavanaugh said that the majority focused too literally on the phrase discriminate because of sex, and it looked at the word specifically instead of the phrase. And he should use the ordinary meaning instead of the literal meaning of all of those words. And the ordinary meaning is not something he thinks people would be talking about when they think of fired because of sex. Whereas the court says literally you are fired because of sex. But the court says just because that wasn't something you would point at specifically when you're being fired, like you could be so sometimes there's been a precedent in the case where a woman has been fired for having young children, but a man was not fired for having young children. She might have been fired for having children, but she would say she was fired for sex-based reasons. And that's where the two come together and create the discrimination, and a protection is afforded to them. So that's also what would happen here. You might not say, I was fired for being gay. You can say, I was fired because of this one issue I did have, like maybe I just filed something wrong, but they would have had more leniency on someone who was straight. And that would be too much to talk about, so it wouldn't really be the ordinary meaning. It wouldn't be the first thing you think about. And that is how the court went against that argument. One second. Yeah, and because you just can't have those kind of discriminations without taking sex into account, it has to be protected by the statute.
Okay, thank you, Alex. That was excellent. Professor Spiropoulos, we're going to talk a little bit about the religion clause cases.
Thank you very much. I'm going to talk about two significant religion clause cases from last term that I think are going to make a huge difference in the future in terms of the relationship between public life and religious people in this country. The first one is the Espinoza versus Montana case. It involves a program that we have, is exactly the same program we have in Oklahoma, called the Tax Credit Scholarship Program, in which we have people who donate to an organization that grants scholarships to people who want to go to private school. So corporations, people who are inclined to help people want to go to school, give money to this organization, and then the organization takes applications and makes grants and scholarships. And the program is specifically designed, both in Montana and Oklahoma, so that you can choose what private school you want to go to, which included religious schools. Don't have to go to religious school, obviously, but religious schools were included. And what happened in Montana was that the Montana Supreme Court said, no, it violates the Establishment Clause to allow people to take money subsidized by the states, because these are donations for which you get tax credits. The state is subsidizing them for people to go to religious schools. That violates the state prohibition against the citizens of religion, not the federal. But the state prohibition, what we call the Blaine Amendments that many states, including Oklahoma, have. Oklahoma's state constitutional language almost exactly the same as Montana's. So whatever happened in Montana would have happened in Oklahoma as well, or at least would have applied arguably to here. So the state Supreme Court in Montana said our state constitution forbids assistance to religious institutions. Therefore, you've got to excise religious schools from this. The state government said, rather than cutting out religious people, we're going to shut down the entire program. So they shut down the entire program, thinking now the whole thing is unconstitutional because of the inclusion of religious people, and religious parents sued, saying that we should have been allowed to participate. The free exercise clause of the United States Constitution forbids you from discriminating against us. And basically, the Montana Supreme Court had ordered discrimination against religious people. The Supreme Court held that the parents were right, that the religious people were discriminated against. The court relied on a long line of cases that's been developing over the last 2 or 3 decades that really started out as Establishment Clause cases, in that when you had a neutral program, giving it to an entire group of people, and you included religious institutions within that group, what states would do if they wanted to exclude or thought about excluding the religious institutions, they would say, we have to do this. We have to exclude the religious people because it violates the Establishment Clause. And over a series of cases, the court has made it clear, no, it doesn't. If you have a neutral program that's based on funding school playgrounds or funding tax credit scholarships, and it goes to a wide range of people, and you just happen to include religious institutions, that's not an Establishment Clause violation, because you're not favoring religious institutions, you're just treating them the same. And so the court made it clear that if you're the state, you can't claim an Establishment Clause defense for excluding religious people. So what states did, right, is that, well, I don't have an Establishment Clause defense, so now I'm going to be using my state constitution provisions forbidding support of religion. And this is the next step, and the most important step in many ways, in trying to protect religious institutions from being discriminated against. Because the court is saying, okay, if you use your state constitution to discriminate against religious institutions, which we've already told you, right, they can be included with no problem under the Establishment Clause, we're now going to allow these people to have a free exercise claim, because the free exercise clause prohibits states from discriminating based on religion. And that's what you've done in applying this Blaine Amendment against these religious institutions. This is not a law that specifically favors them. This is not a law that only included religious people. This is a law that was made for everyone who satisfied these criteria for support. And by cutting religious people out, you have discriminated against them. They need to be included. That means that states who are inclined to exclude religious organizations from these kinds of programs like school vouchers or tax credit scholarships, they're not going to be allowed to do that under their state constitutions. They're going to be required under the federal constitution to include religious institutions in all those, not just school choice programs, but any program, right, that is neutral, that is open to any institution. They're not just going to be allowed, as they have been for many years, to include religious institutions. They're going to be required to include them. They're not going to be allowed to exclude them. That's obviously a huge victory for religious institutions, because now they have a sword to be involved in these programs. They can't be excluded from them simply because of their religious nature. That's a very big deal. The other case that the court decided last term, which is an equally big deal in many ways, although it flew a little bit under the radar, I think Espinoza was much bigger news than this case was a case called Our Lady of Guadalupe, where you had 2 elementary school teachers teaching at Catholic schools. Both of whom had employment law claims. One said she was fired because of her age, and then one said she was fired because she had cancer. And the court dismissed, the court upheld, said that both those claims should be dismissed because of what's called the ministerial exception under the Establishment Clause of the First Amendment. Churches have, church organizations, church institutions should say, have a sphere of autonomy to make their own decisions regarding in some sense, people who act as ministers, employees, right, who are central, right, to the articulation of that institution's faith. And the argument the court said is that, the employees said, as you would expect, they said, we're not ministers. It's the ministerial exception. We're not ministers. We're teachers. And the court said, no. If you understand how Catholic elementary school works, you know that every elementary school teacher in a Catholic school is there to propagate the faith. That is central to their job. And the court said, we're not going to have some sort of rigid black and white rule. We're going to look at the circumstances. What does this employee do? Because everyone's reaction to this case was, okay, what about the janitor? What about the person who's the accountant for the school? Are they ministers too now? And the court said, well, look, we'll see. What is the role that they play in the propagation of faith? But what this means is that this sphere of autonomy is very, very broad. It goes far beyond ministers. We now know it covers teachers, at least at the elementary school level and in the Catholic school, right? And the potential for it is quite broad. And if you look at the concurrence, for example, from Justice Thomas and Justice Gorsuch, they both said, you need to defer to the school. They get to determine themselves who qualifies under this ministerial exception or not. Now, 2 doesn't make 5 votes, right? But the way that this court is going, then you can see, right, that it's not too far for those 2 to get to 5 as time goes on. So what we're talking about here is a significant exemption, right, for religious institutions from many, many laws, depending how big, right, this umbrella is and how many employees will be covered under it. And so both these cases together, along with the Fulton case that was argued yesterday in front of the Supreme Court, and if you saw any reports of the oral argument, the court seemed extremely sympathetic to the free exercise claims of the Catholic Charities organizations in Philadelphia in that case. You are seeing a pattern here of strong intervention by the court on behalf of religious institutions who are, in order to protect religious institutions against, from what the court appears to believe, is an increasingly large state, both an increasingly large government. To come back to Alex's point, Gorsuch explicitly says in Bostock that we will protect religious institutions if from what he's done in Bostock, if the case, if it is necessary. And I think these 3 cases, right, demonstrate that I think the court is ready and willing to do that, to increase the power of religious exceptions, to protect religious institutions from an ever-increasing administrative state.
Well, I've been jotting down several questions as we go, but I think I'm going to piggyback right on what Professor Spiropoulos just said. I think we can directly see a conflict setting up between the free exercise establishment clause cases and the protection that was outlined in Bostock. So I guess I can foresee 2 possibilities. One would be either enlarging that ministerial exception, accepting churches and other, maybe even like applying a case like Hobby Lobby, closely held corporations, from having to uphold those protections that were found in Bostock. Or alternatively, I feel like this might be kind of a fragile Supreme Court precedent that might not live very long in the hands of the new court. So how do you see this conflict shaking out? And I'll ask Professor first, and then we'll move to Alex.
I think you're absolutely right. I think that one of the issues in the case yesterday is whether Employment Division versus Smith should be overruled. And I think if you overrule Smith, which I think there's a good chance, the court might do that. Although what was interesting about the argument yesterday is that Justice Barrett seemed skeptical about overruling Smith, which I guess is not a surprise since she clerked for Scalia, the author of Smith. So maybe the votes aren't there. We'll see. But if the votes are there to overrule Smith, we know Alito wants to overrule Smith. If you study the religion laws classes, before he got on the court, he wrote a very strong opinion, clearly demonstrating he thinks Smith is wrong. But if you overrule this Smith case, which makes it very hard for people to bring free exercise claims against laws that are neutral on its face, like employment laws, if you overrule that, then the RFRA, the strict scrutiny rule that says that if religious people or religious institutions are burdened, substantially burdened by a law, the state can only burden them if they can show, right, that there was a compelling state interest and that the law is narrowly tailored, theoretically the highest form of scrutiny we have. If that's the rule that applies, for example, to employment law, right? If Smith is overruled and strict scrutiny applies to employment law, it's very powerful protections. And I can completely see, for example, Alito and Gorsuch using that, particularly Gorsuch, who now needs to make up for a lot of people who fought very hard to get him on the court. They're very angry at him because of Bostock. This would be a big way for him to say that I've compensated for any harm you think I might have done by this decision. And so, yeah, I do think that is a way for them to square that balance. So it's quite possible. But they could also just do it, as Professor Pappas said with Hobby Lobby, by strengthening RFRA, right, in the federal context, which Hobby Lobby already does. And you can see, and there was another case from last term I didn't talk about involving the Little Sisters of the Poor. It was more of an administrative law case, but also a strengthening of RFRA implicitly in that case as well. So you can see that as being a possibility.
Okay, Alex, what are your thoughts?
Yeah, once again, my internet cut out. So if I repeat anything Professor Spiropoulos said again, please give me grace. I think here the religious exception clauses win, especially when you consider the last main point of majority in Bostock was religious exceptions will be still taken into account. And I have a hard time finding that Roberts and Gorsuch would not allow the religious exceptions, especially when we had those 2 or 3 cases last term that have strengthened religious spheres. And with Amy Coney Barrett coming onto the court, I think she also strengthens the opposition that would allow the discrimination in ministerial roles.
Let me ask you just another follow-up, Alex. As this jurisprudence was emerging, I feel like the argument for trans people was a lot stronger than the argument for gay people. Like, if you're talking about sex, like if you are a person who is transgender, like that is a very much more clear argument to make about sex than sexual orientation. And I think your argument about, for example, a man with young children, a woman with young children, a woman who's attracted to someone named Mike, a man who's attracted to someone named Mike, like that, it's an argument, but I think that the trans argument is clearer than the gay argument, the same-sex attraction argument. And then alternatively, I think the public is more willing to accept protections for gay people than they might be for trans. Like trans issue protections have always lagged way behind other protections. So were you surprised to see the court kind of bundle those together and just say they're both protected?
I was definitely surprised to see transgender people being included into it because, well, like you said, they are the least focused on, at least. Gay marriage, it did encompass them, but they just weren't even in the conversation. When we have these political conversations about LGBTQ people, I, as a gay man, just know gay people had just come off of it easier than trans people do. I think the argument was more persuasive for trans people because a big part of the court was saying you can't fire someone because they are exhibiting just things that you would see in a sex and tolerate in another sex. So hyperfemininity in a man or hypermasculinity in a woman, that would protect a gay person, but it would really protect a trans person, especially if they identify as just straight up, identify as male or female. There is a little bit of confusion on how much we protect trans people who will identify as non-binary or gender fluid, but it seems that this is broad enough to protect them.
Okay, very good. I hope for all of our people who are listening, you're noting how much Gorsuch's name is coming up, and he's really sitting at the very crux of all of these issues. And I know for people like Professor Spiropoulos said, if you've supported him as a super staunch, strong person who's going to deliver conservative outcomes, he would have probably been very surprising as a justice. But I want to ask Jacintha a question. One principle of federalism that we hear about a lot is that we want to see government that's the closest to the people be the level of government that is governing the people. And so that's an argument for states' rights, where you take programs from the federal government, give them to states. You would think that argument would hold for tribal government as well, because of course that's a level that's the most close to tribal people. So why do you think that federalist argument that we should allow tribal governments to be strengthened because they're indeed the level of government closest to the people. Why don't you think we don't see that?
I think it's a very good argument. I think it's a misunderstanding a lot of what exactly tribal governments' roles are. I think there's unfortunately a lot of fear, and you saw that in the McGirt case, with there being a lot of fear about, well, if tribes have jurisdiction, like what are they going to do with it? And I think that that's unfortunately coming from people who haven't spent really any time practicing in tribal courts, because as someone who's practiced in a lot of tribal courts in the state, I can say that I've really seen absolutely no difference in quality of judges, quality of cases, quality of staff, quality of, justice. If anything, I feel like a lot of times I am also involved in some victims' rights or victims' advocacy work, and it's kind of been the consensus a lot of people I work at in that arena that tribes have been better because they have more, like you said, they have more resources. They're closer to the people that are their constituents. It's a smaller group of people, and they're oftentimes closer, and they can provide certain resources that the counties may not have access to, especially, right now. So I think that it's a misunderstanding of tribal resources, a misunderstanding of the systems of tribal government. I think there's like this idea that there are tribes in Oklahoma that have Ivy League attorneys as their judges, we have very educated judges, we have very educated prosecutors, very, highly trained and well-funded police forces. I know that the ambassador of the Creek Nation was speaking earlier, but there's cross-deputization agreements between a significant number of the counties and municipalities in the state and with the tribal governments. I know, for example, Creek Nation Light Horse has one of the only dive teams in that area. So already they're providing a significant amount of resources, not just to their tribal members, but to anyone living there. I learned last year that the only arson dog in the state of Oklahoma is owned by the Quapaw Nation Fire Department. And so that dog and his handler go around like the whole state and actually investigate arsons and then testify, not the dog testify, but the person. I don't know how arson dogs work, but theoretically, right? So I think it's a misunderstanding of the resources of tribes. And, I would just really encourage anyone who has that misunderstanding to go to and visit a tribal court and visit a tribal headquarters, because there's a lot of great resources there. And yes, I think it's absolutely correct that the tribal governments are oftentimes in the best position to provide those resources to tribal members and to non-members who live in those areas as well.
Okay, awesome. Thank you. So I want to change the topic just a little bit. I've been thinking a lot about a book named The End of Liberalism by Theodore Lowy that he wrote like in the 70s. And he was talking about how it's really difficult for like Congress to come to these broad policy proposals and and he anticipated that a lot of the political policies like immigration, affirmative action, Affordable Care Act would kind of be kicked from Congress to the courts to decide. And we kind of have seen this as a political strategy where whenever we either have executive action by the president or we have big acts of Congress, like one strategy is by the opponent is to say, well, we're just going to throw this to the court and try to undo it somehow. And it's just sort of like what's been happening both on the left and the right. And so in that context, we have challenges to the Affordable Care Act. And one major case, two combined, California versus Texas is going to be heard soon. And the crux of that case is that because the constitutionality of the Affordable Care Act was the fact that it was characterized as a tax and not authorized through the General Welfare Clause, once we had the individual mandate kind of like dialed down to zero, does that invalidate the constitutional basis of the Affordable Care Act? So if the Affordable Care Act is deemed unconstitutional and thrown out, then Medicaid expansion support from the federal government would go away. private subsidies for health insurance policies will go away. Protections for pre-existing conditions go away. So as the court looks at this case, first they're going to examine whether they're standing, then they're going to look at whether reducing this penalty to 0 renders minimum coverage provision unconstitutional, whether that invalidates it, and then whether that is severable from the other part of the act. So this is also one of the first major cases that we're going to see our new Justice, Coney Barrett, decide. So we have a pretty polarized Supreme Court. So I wanted to kind of have you all look into your crystal balls and think about what we think the Supreme Court might do. Are they going to uphold the ACA, or are they going to invalidate it and move us to a different form of healthcare? So who would like to go first on this?
I'll go first.
Okay.
There is zero chance they're going to strike down the ACA. Zero chance whatsoever. It's one of those things. We as lawyers are cursed with actually following these things and knowing as we go along. So those of us in the business know this was one judge, right, who's known for his creative and aggressive interpretations of these provisions. And it was shocking when he made the decision that it's a district court judge in Texas. And there is no one in this business who thinks the Supreme Court is going to strike down the Affordable Care Act in this case. No one thinks that. It's not going to happen. They're going to hold that it's severable, and they're going to hold the penalty provision is still there even if it's 0, and even if for some reason the penalty provision renders it nugatory, Congress just make it 50 cents, right, and restore it. So there is zero chance, right, that the court is going to strike down the Affordable Care Act.
Why take the case then? Why don't they just deny cert?
It's a great question. I think perhaps to fix the severability doctrine, just to make it clear, right, that this was an insane interpretation of the severability doctrine. I agree. There's a reason they're trying to clean something up, all right? But there's no one seriously believes. And I think even the Democrats who were fighting against Justice Barrett, they didn't seriously believe what they were saying, because everybody knows this is not going to happen. But I agree with you. It's interesting why they took the case. They clearly want to clean something up that needs to be cleaned up. It's likely to be 9-0 or close to that. But there's just no threat here. Had serious threats in the past, and they've been resolved. But not this one's not serious. There's just zero chance, in my opinion.
Other thoughts on this?
Everything I learned about the Affordable Care Act and how the court will react to it, I learned from Professor Spiropoulos, so I don't have too much to add. I definitely agree. I think if the court does try and overturn the Affordable Care Act, it will be so clearly political, and I think that the court is wiser than that. I think it would kind of chip away at the legitimacy of the court.
Well, that's an excellent point. That this is the one area where the Chief Justice in particular, right, has been very careful in terms of how to guide the court through this. I don't think you'll have to do that this time. I think it'll be so overwhelming that there won't be any issue. But that's a really good point. Important to remember, Alex.
Jacintha, did you want to try and chime in?
I don't really have a lot to add. I definitely agree. And I also took Professor Spiropoulos for common law in a number of other classes. So I think that our analysis would be fairly similar. But I do agree. I think that, at this point, we've seen numerous challenges. And if the court was going to strike it down, like, this is not necessarily the case. I think that this is not the strongest case that the court could have used to strike down the Affordable Care Act. So I do think it's interesting why they took cert, but I do think that maybe the severability is something that they may want to change. But I think at this point it's fairly well established precedent. And I don't know. I think Justice Gorsuch has. I don't think we know what the new Justice Coney Barrett's going to do necessarily, because we haven't really seen what she's going to do yet. But I think that Justice Gorsuch has shown that he's a fairly he's very measured in his opinions and in his reasoning, So I don't see him, I agree. I don't see that it being, I don't see it being overturned on this particular case when they've had other opportunities to do so. I don't know that it'll be 9-0 though. I'm not that optimistic.
It can be different on different issues. That's right.
Well, at this time, we have a few more minutes. If anyone in the audience would like to ask a question of any of our panelists, I know that they would be delighted to field that question. Any questions?
I have a question, Dr. Pappas.
Yes, Will.
So I'd be interested to hear everyone's thoughts. It was kind of alluded to, Chief Justice Roberts' institutionalist proclivities, you know, protecting the legitimacy of the court. I'm curious to know what everybody thinks the effect of Justice Coney Barrett's appointment will have on that, if we're going to see Justice Roberts get more comfortable with some things that maybe he would have been uncomfortable with when there was a closer split previously. So
I think that's a good observation. I think he has in the past sided a certain way so that it would be a bigger discrepancy is the word I'm going to use between the majority and the minority. We know he doesn't love a 5-4 split. If he can make a 6-3 split, he will, if it doesn't come at too much of a cost. And I don't think, as of right now, I don't see Amy Coney Barrett really being an issue in that, because I've been seeing Gorsuch and Roberts kind of going differently than we have been seeing them go. So if we keep up that trajectory, then it won't really be any kind of persuasion. But I mean, it's clearly going to be a problem sometimes. Not a problem, but it will clearly be a distinction at some points.
Well, we know Roberts hates the politicization of the Supreme Court, so I can't imagine that he was too happy with, you know, the quick confirmation and just, you know, the fact that the public wasn't along, you know, going, if the whole public had been saying, yes, let's do this right now, but in fact, there was quite a lot of people that were pretty uncomfortable with it. So I bet we'll see him try to enhance the legitimacy of the court by kind of dialing down the politics if possible. I don't know that that's possible, but I think that's what he would want to do.
I don't disagree. Although I think the fact that it looks like Republicans have kept the Senate, so that makes a huge difference. There's no threat now to the court, and it's more than the fact that the Senate will check any attempt to check the court. It's clear that the American people weren't bothered, or at least half the American people weren't bothered at all by what happened. In fact, the Republicans in general, actually putting the presidency, which is kind of a big deal, aside, Republicans did really well, right, in this election. Particularly in Congress. So I think Roberts is going to take that as saying, yeah, things fine, right? And McConnell will stop any threats to the court. We're actually free now it's crazy enough to cite cases on their merits without having to worry about this. And I think that Roberts is just a different kind of believer in judicial restraint than Barrett or Gorsuch. Roberts is not a textualist. And he's not an originalist, right? He's an old-fashioned believer in judicial restraint. I mean, he is who he's always been, right? And so he's skeptical. He's a believer in stare decisis and precedent, and he was taught, what we call the legal process school of jurisprudence. That's been around since the 1940s and 50s at Harvard. He's a product of that tradition. These people after him are different. They're a different kind of conservative judge than he is. And so he's going to be a little out of step. It's going to be difficult for him, right? He's not going to be the fifth vote, right? I agree there are going to be times where he will add a sixth vote. For example, Alex, you might disagree. Frankly, I don't think he agreed with Gorsuch in Bostock. I think he was protecting Gorsuch by signing on to that opinion because he didn't say a word. He did not want Gorsuch to be the 5-4. In that decision. I think Roberts thought, it's going to go that way anyway. I might as well give cover to him. That's the kind of thing that Roberts does, because that's the tradition in which he is. But it's going to be harder for him to do that, right? Because he's going to be the extra vote now. He's not, and what he's going to have to do, right, in order to assign the opinion, he is going to have to join the majority in cases that he disagrees with the approach. So by definition, he's going to have to be more originalist, at least join that majority to do that. And the other factor we don't know yet is we don't know yet what kind of originalist or textualist Barrett is. Gorsuch is one of the great lines in Bostock is Justice Alito says this is the pirate ship of textualism, right? It flies the flag of textualism, but it's not textualism at all. Which, by the way, Alito's absolutely right about that. There is absolutely no way Justice Scalia would have joined that opinion by Gorsuch. Not in a million years would Scalia have agreed. Scalia was absolutely clear, right? It's ordinary meaning of the language at the time the statute was passed. There's just no way. But we don't know where Barrett is on that. I suspect she's more like Scalia than she is like Gorsuch. I think Gorsuch is a pirate ship of his own. I think he's a very strict textualist. I think the same thing goes for McGirt. I thought Roberts' opinion of McGirt was superb because it's a superb legal process opinion where Roberts says text is not everything, right? This test that we applied in Solomon is too rigid for this. Oklahoma is unique. The history of Oklahoma is unique. If you look and see what happened at the time, what Congress did at the time, and you look and see what's happened ever since then, Roberts says, you got to look at the structure of the law. You have to look at the precedent. You have to look at the practice of everything that's happened since then. You have to look at every source besides the text. They just flat disagree with Gorsuch on these issues. So so we have to see. My suspicion is that Kavanaugh and Barrett will not be like Gorsuch. That Gorsuch will be by himself a lot of the time. I think he's a much more rigid textualist than they are. But I don't see him having much support for his approach on the court, unless I'm counting. I'm not seeing a lot of votes there for him.
Okay, so we have time for a little bit of a lightning round of two questions. And so we've had some questions from the audience. One is, do you think the court packing idea is going to come to pass if Biden is elected? And the second one is, what will the court's role be in the election, in the presidential election? So I'll just say if Biden gets elected, I don't think he's going to pack the court. I mean, add seats to the court. I don't see him doing that. And I don't know. I don't know about the other question. So other thoughts? Jacintha, what do you think?
Well, I mean, with the court packing, he can't do it without, he doesn't have the Senate. So, that's not, yeah. So I don't really think that that obviously can't happen. I think, I honestly, I don't know for sure. I think this is a really interesting, it's just an understatement. This is a really interesting election. I think it's going to depend on how, maybe at the end of today, we'll know, maybe at the end of tomorrow, how close things end up coming, how many of those, what the result ends up being, right? How close it ends up being, and then particularly what ballots. Was it mail-in ballots? Was it ballots that were, I'm totally forgetting the word, but I know there's ballots that are being recovered because there were maybe some errors made on those, and the timeline by which those states finish counting those mail-in ballots. So I think it'll really depend on how close it is, and then the timeline on those states, and then which particular ballots end up being the results. So if it ends up being very close, and some of these ballots that were essentially recovered or fixed end up being the deciding vote, then I think we're going to see a situation where the court's going to be getting involved. I just, if it was on the other side, it would too. That's just not, it just is what it is. That's what happened, essentially in 2000, right? So I think it will just, I think we won't really probably know until tomorrow. So.
Yes. What about you, Alex?
I don't think Vice President Biden is even really open to the idea of packing the court. I know the Senate would not be behind him at all for it. I think if this case was in a position to go to the Supreme Court, it would go to the Supreme Court and they would decide it. That's really all I have. I don't think, we can't really tell what they're going to do. But I just think that they would pretty much, because we don't know the cause of action really yet. So it's kind of hard to say what exactly they're going to do when we don't really know what the claim is. There have been a lot of different claims for a lot of different areas, and it's kind of interesting to see how he's going to aggregate them together if we do bring it on either side.
Certainly. Professor?
I think the court in the pre-election challenges cases have been pretty consistent. It seems their principle is no changing the rules. What the rules were before, they need to stay where they are. And I think that's the safest political ground and legal ground, strangely enough, on the merits, for the court to adhere to.
Do you think the Chief Justice is crossing his fingers that these things get resolved before they come to his doorstep?
I think that's likely to be the case. I really do. It's mostly to be a lot of noise over the next few days, maybe a couple weeks. But at the end of the day, it looks like it's going to be fairly straightforward, but who knows? You just don't know what they'll find.
Yes, yes. I remember reading Too Close to Call, Jeffrey Toobin's book about Bush versus Gore. And I remember the take-home message from that was the Bush team just always looked better because they just projected that they were winners. They talked about being winners. They wanted to say they're winners. And I feel like Donald Trump must have read that book because he's like, I'm the winner, I'm the winner. And it was just a different time as it was back then, but very similar issues.
James Baker is a lot more persuasive than Donald Trump is.
Yes. All right. Well, I think we're out of time. I want to thank our panelists. I think this is a tremendously awesome discussion about the role of the Supreme Court and some of the major cases that we've seen in the last term and then in the term that's just gotten underway. I want to thank all of our audience for participating in this panel. And the next thing on the agenda will be the keynote speaker lunch. It's on your, you can watch that video. So thanks once again. Thanks to our panelists and thanks for participating. So goodbye, everybody. Thank you.
Thank you, guys.
Thank you.